My name's Philip Theodore. I'm the presiding officer for today's final session, which will present a mock negotiation of some very important and frequently contentious terms that often arise in the context of a business combination transaction. I can think of no two more suited people to conduct this panel than Richard Climan and Joel Greenberg, who are up on the stage. Richard's a Silicon Valley-based partner in the mergers and acquisitions group at Hogan Lovells. He heads Hogan's global technology practice. And he recently burnished his reputation by representing Walmart in its $16 billion acquisition of a minority interest in Flipkart, which is a very interesting Indian e-commerce company.
Majority interest.
Was it a majority interest? What did I say? I'm sorry.
Minority.
I'm sorry. No, actually, it was a majority interest. Our co-panelist is Joel Greenberg, who's a New York City-based senior counsel with Arnold and Porter. Joel has a very broad-based practice. He does a lot of M&A for strategics and financial sponsors, and he also does a bit of corporate finance. Among other accomplishments, he co-chairs the annual National Institute on Negotiating Business Acquisitions, which is sponsored by the ABA section of business law. So I'm going to turn this over to Richard and Joel. Guys.
Well, thank you very much, and good afternoon, everyone. Welcome to our last panel of the day, our bi-coastal simulated negotiation panel. This is the panel where we get into the nitty-gritty of drafting acquisition agreements. And of course, there is nothing like a two-finger pour of Bushmills to keep things freewheeling and fast-moving. So thank you, Byron Egan. We should all raise a glass to Byron Egan for being such a gracious host and generous bartender. My name is Rick Climan, and I'm an M&A partner in the Silicon Valley office of Hogan Lovells. Joining me on the panel, as always today, is Joel Greenberg, senior counsel in the New York office of Arnold and Porter. Joel and I have done this panel for many years now, but I would say, Joel, it's probably fair to say never quite in a market like what we're seeing now. And part of our job today is to give you all a sense of what's happening in the current M&A marketplace on both the strategic side and on the financial sponsor side. Conveniently enough, you may have seen this, those of you who subscribe to Law 360, but the Refinitiv league tables all the way through Q3 just came out yesterday. And they tell a story very similar to the story that we heard from the panel right before this. Suffice it to say, it's a challenging time for private equity sponsors. It's a great time to be a cash flush strategic buyer. And we'll elaborate on that a little bit as we go through today. But before we get started today, I'd just like to get a brief sense of the audience in the room. So if you wouldn't mind just by raising your hands, how many of you are actually law firm lawyers? Well, that's a good number. And how many of you are representatives of rep and warranty insurance carriers or brokers? Thank you, that's helpful. So our basic fact pattern for today's illustrative negotiation is a pretty simple one. My client is the target company, which we will assume is 100% founder-owned. So in addition to representing the target company, I'm also representing the founder, who is its sole stockholder, and if a deal moves forward, will be selling 100% of her stock in the target company to a buyer. But bear in mind that although the positions that we're going to be taking from a negotiation standpoint today and the negotiating outcomes of these positions are probably not going to change very much from what they would be if the target company were venture-backed. To provide some hypothetical context, we can assume that the target company is an up-and-coming profitable company with a solid growth trajectory. I won't say what sector it's in, and has attracted a little bit of interest, modest interest, from maybe a few strategic and maybe even some private equity bidders in the recent past. So my client has meaningful negotiating leverage, and she's not in a position where she absolutely has to sell the company. But the seller is, for the time being, focused on one particular potential buyer, a large cap publicly traded strategic buyer represented by none other than Joel Greenberg. Though I should warn you now that at various points in our presentation, we're going to switch things up a little bit. And we're going to assume instead that the seller and the buyer are both financial sponsors, so we can contrast the PE marketplace with the strategic one. They're different markets, and they become even more different with the passage of the last 9 to 15 months or so. But for now, assume we're dealing with a strategic buyer of a founder-backed company and not a sponsor-to-sponsor deal. The parties are in the midst of their negotiations. They've aligned on a purchase price of, say, $300 million for all of the outstanding stock of the target company. The parties have, of course, signed a fairly standard confidentiality agreement, but there is no exclusivity agreement in place, so the seller is free to explore other options if the negotiations aren't going well and if other options really exist in this market. And the parties have also signed a so-called common interest agreement, which has enabled their lawyers to have privileged discussions between them about the antitrust aspects of the deal. And as a result of those discussions, the parties have concluded, even though this is the sort of deal that, say, 4 or 5 years ago would have sailed through the HSR process without a hitch, in today's super restrictive antitrust environment, featuring, as we've all seen, hyperactive government antitrust enforcers, an extended HSR review period is a distinct possibility. So though the parties are confident the deal will ultimately go through, there could be a 5 to 6 month or even longer delay between signing and closing. So it's against this backdrop that our negotiations begin. Now, Joel, and those of you who are familiar with Joel or who have negotiated against Joel in real life know that this is a fairly typical scenario. He has proffered his usual 120-page monstrosity of a first draft of a definitive stock purchase agreement. It's a Joel Greenberg special. It's exasperatingly dense, and it's filled with sneaky traps for the unwary seller's lawyer. But frankly, most of the outrageous stuff isn't really sneaky. It really isn't buried or concealed at all. As we'll see in a moment, the draft is very much in your face and reflecting Joel's, I hesitate to say it, Joel, but overbearing, buyer-oriented approach that you take when you're on the buy side. You zealously represent your client.
I prefer to view it as following Chancellor Chandler's admonition to be a forthright negotiator.
Yes, forthright to the extreme, forthright on steroids. So now, we're obviously not going to have anywhere near enough time to address all, or for that matter, even most of the controversial provisions in Joel's draft. And because this year's UT program does not include a separate indemnification panel as it has in past years, the UT organizers have asked us if we would please focus on the always controversial post-closing indemnification provisions, and we're going to endeavor to do just that. So, Joel, I've taken a few excerpts from your draft indemnification section in your bloated stock purchase agreement, and I put them up here on the screen in the big, bold type that they deserve, and hopefully everyone can read them as we go through them. And for those of you who are nearsighted like me and don't have access to this on your laptops, we've distributed hard copies of our slides. I think they're on all the tables, so you can turn to that now. But first, Joel, right here at the outset, I'm going to try to save us all some time and countless hours of tedious negotiation, given the marketplace realities that we've already heard about from other panels, but really the marketplace reality of the past 4 years. I'm going to shortcut the process and ask for a no indemnity deal. And as you know, Joel, no indemnity deals are very common these days. They're facilitated by the thoughtfully designed and comprehensive policies of rep and warranty insurance that are available in today's market from very highly rated carriers. And there are probably half a dozen great brokers we already saw by show of hands that are sitting right here in this room who can help your client find the right buy-side policy. So what do you think, Joel? Just can we eliminate the indemnification provision altogether and just go home? And let me tell you also off the record, just to cement this deal, my client, the seller, might be willing to pay part of the insurance premium on the rep and warranty insurance policy, maybe as much as 10% of the premium to get a deal done. So what do you think? Have a deal?
Rick, I think you're talking about the realities of the wrong market. Basically, in today's world, large strategic buyers like my client are not willing to live with rep and warranty insurance. I mean, there are just, it's a great product and it's got enormous use in some contexts, but given what our needs are, it's just not going to beat them. You've got, first of all, inevitably, the insurer is going to start picking over the representations and deciding it might not be able to cover this one or that one. Certainly, it's not going to cover the 10b5 rep. And second, you've got this pesky little problem of what they call interim breach, where we're talking about conditions that occur between the signing and closing and are discovered between the signing and closing. And as to those, the typical rep and warranty insurance policy provides zero coverage. That's it. The market has moved a little bit in the insurance area, and you can now start to get interim breach coverage on some deals, but not a deal this size. I mean, this one is too big at 300 million equity value to get interim breach coverage. And it's going to be a real stretch to get them to cover a period as long as we're looking at because of antitrust. You know, it's a great solution if you're doing a mid-market PE deal and you're going to close 30 days after you sign. Then you can get your interim breach covenant, but not here. So, Rick, it's nice of them to offer to pay part of the premium, but the premium isn't the issue, it's the coverage.
Let me ask you, Joel, would it change your mind if my client agreed to pick up 100% of the premium? Does that change your calculus?
Not really. I mean, that's just, you know, I view that as just shifting the purchase price slightly.
Okay, Joel, just for market comparison purposes, let's change the facts and assume this is not a strategic acquisition, but rather a sponsor-to-sponsor deal with zero antitrust risk. All right, so we're probably talking about a period between signing and closing of a little over 30 days. So representing the PE sponsor on the buy side against a PE sponsor on the sell side here, are you going to be more receptive to doing a no indemnity deal in the current market?
Yeah, I am. I mean, the market is different, and it's different for a couple of reasons. It's different, one, because we're dealing with a small community and everybody sees each other on both sides of the deals all the time. So what I demand today, I'm going to have demanded of me tomorrow, and with precedent to show. It's because the same law firms, the same sponsors are doing deals with each other all the time. Second, the interim breach problem is a much smaller problem with a 30 days to close than 6 months or more.
Because there's a much lower probability that something that constitutes an interim breach would show up.
For anything to happen. And lastly, in a sponsor-to-sponsor deal, what I typically get a lot of comfort from is the fact that you're going to have a small team of key managers who are rolling virtually all their proceeds from the first deal, or certainly a substantial portion of them, into my deal. And so anything that I suffer after the closing, they're going to suffer too. And they're in the best place to tell me about warts that are floating around there.
Right. And you didn't mention some of the other gaps in the coverage of rep and warranty insurance. For example, pre-closing covenants, which can be very important in these deals. Sure. Does that affect your thinking on this as a strategic?
Yeah, although I will tell you that it's certainly something I will, as you've seen from the draft, try to plug. But we're going to have a negotiation, and we're going to wind up, I would suspect, parsing the pre-closing covenants, and some you'll let survive and some you won't. I mean, if you'll give me a surviving indemnity on operate the ordinary course, I've done a good job and you haven't.
But isn't that what some buyers have sought to do? Again, stepping out of character here to say, okay, we'll rely on rep and warranty insurance as long as you indemnify me for all the gaps. And that sounds good in theory. I've never seen it happen in practice. I know, Joel, you mentioned to me earlier today that you actually succeeded in getting that arrangement. Very rare, and it's just not in the cards.
It is rare, but I just did a deal with a large pharma strategic where we did exactly that. And it became very complicated, as you say, because one of the things the rep and warranty insurer did is they decided they were going to renegotiate for their purposes 3 or 4 of our reps, so that we even had different rep coverage. We had the interim breach issue. It's complicated, but it got us to the point where we had full indemnity coverage, right, albeit some of it from an insurer.
Yeah. And even before the current market conditions expressed themselves, large strategic acquirers were very reluctant, as a general matter, to rely on rep and warranty insurance unless they were forced to do so because they were playing in an auction with other private equity buyers that could offer, in effect, no indemnity deals. And the fact of the matter is that those pure auction processes are much less frequent today than they were 2 years ago. And
So I think we're stuck with the indemnity provisions for today.
Yeah. So let's go back to our original fact pattern, strategic deal. And I guess we're going to have to work through your very broad indemnification language. And the first excerpt is from your operative indemnification provision. It's up on the screen. Let me read it. It says, seller shall indemnify buyer against any damages directly or indirectly incurred by buyer as a direct or indirect result of, or directly or indirectly related to any inaccuracy in any of the seller's representations. Joel, do you think this is standard verbiage for an indemnification provision?
Certainly a standard start point.
So, because I don't think it's standard at all. Honestly, Joel, I actually think you may have some sort of weird medical affliction that I might call indirectly-itis or something, and I hope it's not contagious. But let's count the number of times the word indirect appears in this single 35-word sentence. I count 3, and the phrase directly or indirectly accounts for about 25% of the words in this sentence. Why do you feel you need this directly or indirectly verbiage? Why do you keep repeating it over and over and over again?
Look, partly because I know some of them are going to come out in negotiations, and I want 1 or 2 left. But also, what we're trying to do is ultimately give direction to a court that they're supposed to read these things broadly, and that if there's a chain of events that runs from a breach to damage that my client suffers, we don't want to start getting into arguments about whether it would have been recoverable at common law in 1850, when you cite Hadley against Baxendale to me.
But I'm glad you raised that, because that's exactly why I object to your provision. It's an attempt to undo almost 200 years of settled Anglo-American jurisprudence. Because when I was in law school, they teach us about that case named Hadley versus Baxendale, decided in 1854 to be precise. And I'm sure you learned about it when you were in law school, Yale. Am I right about that?
Yep.
Of course, when you learned about it,
we got it in the advance sheets.
Yeah, it was probably a recent case when you learned about it, but it stands for the proposition that indirect damages are not recoverable, only foreseeable damages are, and your client should not be able to recover unforeseeable damages arising from some unforeseeable Rube Goldberg type chain of events, or if I can mix my contract metaphors with my tort law metaphors, arising from some completely unpredictable Paul's-Graphian scenario. Remember the Paul's-Graph case from tort law class? Anyway, I'm not going to agree to that verbiage.
Look, first of all, direct or indirect doesn't necessarily go to foreseeability. It goes to how long the chain of events is. But quite candidly, I think we can probably get some of that out here. But I will tell you that I don't consider myself bound by a common law that arose in an era where what people were suing about were broken camshafts and carts and barren cows and things like that. I mean, the world has moved a little bit, and your company isn't like that.
Joel, I couldn't disagree more. It is a venerable principle. It's withstood the test of time. It's as appropriate now in technology-related disputes as it was 2 centuries ago in disputes about busted crankshafts. So check out the screen, and here's what I propose to do to your language, which, by the way, we can talk about this, and I do see the directly or indirectly verbiage in a lot of buyers' first drafts, but I definitely do not think it's a market standard. So first I'm going to delete all the directly or indirectly's. I'm going to eliminate it entirely. I'm not going to just leave directly in there because I can see that that would be going too far in the other direction. Next, I'm going to delete your relating to clause because it expands the causal nexus in an unsatisfactory way, because consequences that somehow relate to a breach may not have a causal relation to the breach. So that goes too far for the same reason that directly or indirectly goes too far. There has to be a foreseeable causal relationship between the breach and what triggers it. Third, I'm going to add the word foreseeable before damages, just to enshrine the venerable principle of Hadley versus Baxendale. And fourth, in the same spirit, I'm going to delete the reference to lost opportunities in the definition of recoverable damages, because lost profits and the like should not be automatically recoverable. I'll concede that they are recoverable in certain contexts, but whether they're recoverable or not should be a question of the particular facts in each case, including whether they're foreseeable. So, Joel, I'm going to ask you to step out of character. You've already hinted at this, that these types of changes, especially getting rid of the directly or indirectly, are changes that you're probably inclined to agree to if you get called on.
I think when we get there, what I am inclined to agree to are to delete what I will call most of the words of expansion. So I'll take out directly or indirectly. What I'm not particularly sympathetic to are your attempt to put in words of limitation. So that reasonable attorney's fees is all right. I'll give you that one. But, for example, to look to the end, your consequential damages exclusion is not going to fly. And I think that diminution or decline in value is absolutely an appropriate measure if it sources from the breach, because that may be the only way we get made whole.
Fair enough, Joel, but before we get to those points, which we will get to, the idea of crossing out directly or indirectly, probably okay, right?
As I said, that one I'm probably willing to do for you.
And then relating to, I mean, we've talked before about how that really expands the universe of things that are recoverable from caused by or as a result of.
I think I would be willing to say caused by or resulting from or something like that.
Fair enough. I just have to say, based on my experience on the buy side, I am frankly amazed at how often the sellers fail to push back on the directly or indirectly or relating to verbiage. These are fundamental issues that they should win, and not pushing back on them has really substantive adverse effects on the sellers. And instead, they tend to waste their time focusing on fringe issues of much less substantive import. So this is a lesson for those of you who frequently find yourself on the sell side, and I know that's a fair number of you, and I will regret saying this if I ever find myself representing a buyer opposite any of you. Even in what's become much more of a buyer's market, you should not be putting up with this overbroad buyer-oriented verbiage. You owe it to your client to fight back on this stuff. So let's jump back into character, Joel, with you forcefully representing the strategic buyer. Buoyed by my success in this last round of negotiations, as you can see, I have added an exclusion to the definition of damages at the very end, in red, that says you specifically exclude consequential damages from your definition of recoverable damages, because I see consequential damages disclaimers in all types of agreements, consulting agreements, IP license agreements, and on and on and on. And I don't know why this type of contract, a business acquisition agreement, should be any exception to that at all. And if I recall my law school contracts class, consequential damages are basically the same thing as indirect damages, and you've already agreed to cross out the words indirectly in the main indemnification paragraph. So you good with the consequential damages?
Not a chance. Not a chance. And look, the contracts you're referring to tend to be contracts where the transaction value is way out of proportion to the harm that be the source of a damage claim. For example, you've got somebody takes on a consulting assignment, and they're going to get a fee for a month's worth of advice, and they're not prepared, just as a commercial benefit bargain thing, to go on the hook for overall damage to the value of the business if the advice goes bad. Or if they say if you get to sell a software program that has a glitch in it, and the glitch, it winds up costing the buyer a lot of money. I think you'll find the license agreement you signed, one, excludes consequential damages, and two, limits recovery to the amount of the royalty paid to start with, the license fee. But this is completely different. We are buying and paying for the entire goodwill of this business. And so if it is destroyed by something that occurred on your client's watch and was the subject of a representation or warranty, there shouldn't be a limit simply because it's a big number and it was unlikely to happen. It did happen. And so the consulting software kinds of agreements, are really no relevance to me as a precedent here.
Right. But you've already agreed to exclude indirect damage.
No, we didn't. We agreed to take out the express inclusion of indirect damages. That's a little different. You said you wanted to rely on the common law. And I said I was willing to live with taking out direct or indirect. That doesn't mean that I was willing to say, but not indirect damages. I'm willing to let the tests of contract claims fall where they may. The big difference. And now let me just add one other thing about consequential damages. I don't know if Glenn is in the room, but one of the speakers here tomorrow has spent a good portion of the last half dozen years writing about why no one knows what consequential damages mean in the context of M&A agreements. And so you are agreeing to something where it is entirely unpredictable what a court's going to do with it.
Right.
And I don't like...
Stepping out of character, Joel, then Vice Chancellor Strine, one of our favorite Delaware jurists, is on record as having said that words like consequential damages are either inserted or excluded from provisions like this by lawyers who really don't know what they mean. So they really didn't teach us very well in law school because it is hard to know what consequential damages are.
And particularly, it's hard. You have to think of this in terms of what is a court going to do with it if the claim is in front of it. And the simple answer is, in the M&A context, in many cases, I don't know. And if I don't know what it's going to do, it isn't going in a contract that I'm recommending to my client.
Right. So let me try to take one more shot at this, Joel, in character. I know you're a former chair of the ABA's M&A committee, as am I, and I just checked that committee's private target M&A deal point studies for the past decade, and the consequential damages waiver I'm requesting appears in these agreements much more frequently than I think you might think, because according to those studies, sellers win this point anywhere from 25% to 50% of the time. So this appears to be the kind of thing that sellers win on a good chunk of the time. What do you have to say to that?
What I have to say is the deal point studies, I think, are a great product because there was nothing else like them. But you also have to understand where they come from. And where they come from is an analysis of agreements filed as exhibits to SEC filings by the buyer, so since these are private company acquisition agreements. And that means that we have a very distorted universe of transactions in there, because I'll tell you, the client I'm representing in this deal, they never file acquisition agreements with the SEC. None of them meet a materiality threshold. And I dare say that if you wanted to find out what Microsoft's acquisition pattern was in agreements, you couldn't do it by surveying the M&A agreements they file with the SEC, because they're not there. What you've got is a lot of agreements filed by mid-market or smaller public companies and on a variety of sellers, but a lot of them basically sellers who are founders or other smaller public companies selling a division. It's a limited body of precedent, and I will tell you that, well, I don't have statistics to point to because this stuff is private. If you talk to anybody who represents bulge bracket strategics in M&A work, they will tell you that the market is very different from what those deal point studies show on this point and quite a number of others too.
And out of character, I agree 100%. I spent a lot of time on the buy side as well, representing large and mega cap strategic acquirers primarily, but not exclusively in the tech sector. never agree to an exclusion of consequential damages, no matter what the leverage equation is in the deals that they do. So buyers should win this point, and it's an important lesson for those of you representing buyers in the strategic marketplace, even in smaller deals, frankly.
And if you want more of the details, I commend to you 2 articles that are pretty easy to find in the Annals of the Business Lawyer, written by Glenn West. Both have consequential damages in the title. And there's a lot of case law in there, and you read both articles and you'll come away knowing that you don't know what consequential damage waivers do too.
Never agree to it. I mean, it's a pretty bold statement. And so I'm curious. I mean, some areas, especially the energy, which of course here in Dallas, there's lots of people that do energy work. The vast majority of the value swing is in the title and environmental due diligence provisions. And so just wondering your thoughts on waiver of consequential damages in the context of a PSA in, say, the upstream.
Again, putting on my buyer's hat, I think in a fully priced acquisition in the M&A context as opposed to other contexts, those should be recoverable. The hypothetical, as you know, that we often give to illustrate how important a consequential damages waiver can be for a seller is the situation where one of the basic representations about compliance with law, which applies to energy companies as well, and it turns out that representation is wrong, and as a result, the target company's plant is shut down for 6 months waiting for them to get the permit that they should have had, but they didn't have. And representation that says you have all permits necessary to operate the business is wrong. The 6 months of lost profits, Joel, you're going to want to recover. But the $15,000 fee for getting the license, that's not enough. You want recovery for a full measure of damages in that context.
Yeah. And I think the key point, again, from the buyer's perspective, is I've paid for those profits. If the fully priced deal reflects the expected cash flows from the business, the whole business. And if part of it is shut down because the seller forgot to get a wastewater discharge permit and it's discovered 2 months after the closing, as you say, giving me the fees to get the permit is not going to make us whole or even close to it.
So next issue, Joel, still focusing on your definition of damages, which remains up on the screen here. In particular, and I'll go back to the original language here, I'd like to understand your parenthetical in the definition, which describes the circumstances in which my client is required to reimburse your client's legal fees. So let's look at the first component of your parenthetical, because your parenthetical has 2 separate components, the first of which I agree with, and the second of which I don't. But let's look at the first component, just so I can fall on my sword and make a concession that I won't object to your first component. What this component seems to be saying is that if the seller, my client, has breached one of its reps, and there's a related lawsuit by a third party after the closing, the seller, my client, will pay the buyer's legal fees in defending that lawsuit. So, for example, if a third party sues the target company, which of course is the buyer's subsidiary after the closing. So this is a post-closing lawsuit, rightly alleging that the target has infringed the third party's patents, for example, before the closing. And if the seller made a specific representation, as it almost always will in the acquisition agreement, that the target company did not infringe prior to closing any third party's IP at all, then the seller and not the buyer should pay the legal fees incurred in defending that third party lawsuit. And we know that when it comes to infringement claims, we're talking about potentially tens of millions in legal fees. It's not chunk.
I mean, to me, that seems uncontroversial. And quite candidly, the only reason, because those are foreseeable damages from the breach, going back to your Hadley concept, we're going to get sued for infringement. We have to spend a lot of money in an effort to defend it. But the only reason you put that kind of language in an agreement is that there is this traditional notion, which comes up in other places, and you're about to get to it, that attorney's fees don't get included in the awards from lawsuits unless there's a fee-shifting statute or something, the so-called American rule. And we don't want any risk that a court is going to say, oh, no, the American rule is every party bears their own attorney's fees, therefore we're not going to indemnify you for the fees of defending against this third-party claim.
And Joel, you had me at hello there because the principle does seem fair to me, and I can accept it, maybe with some minor language tweaks. Those legal fees are properly indemnifiable damages, in my view, so we're in agreement there without you really having to say a word. But what I don't think I can accept, because it is a more direct violation of this American rule, is the second component of your parenthetical, which says that my client, the seller, has to reimburse the buyer for legal fees incurred by the buyer outside the context of defending a third-party claim. In other words, in the first-party context. For example, in a first-party indemnification dispute between the buyer and the seller, you may be suing us for indemnification that has nothing to do with a third-party claim. It may be a first-party claim that my assets weren't worth as much, and you're going to ring up these incredible legal fees with your high-priced counsel, and then say at the end of the day, no matter what the outcome of the dispute, that, well, these are indemnifiable damages in this first-party dispute. I just can't agree with that because it violates the basic American rule that in a lawsuit between two principal parties, each side pays its own legal fees. And you've drafted this in a one-way manner so that the seller always has to pay the buyer's legal fees, but the buyer never has to pay any of the seller's legal fees. So to me, this is an example of that sneaky over-the-top drafting that I referred to earlier. Will a court even enforce this provision?
Well, they enforce it. I don't think there's any real question that they would enforce it. The real question in getting these things enforced is to make it crystal clear to the court that's what you want. There was a case in the Superior Court in Delaware a couple of years ago where a court actually enforced a provision like this, and they did so on much less clear language. I mean, the reasoning was tortured.
But they did honor the notion that for this particular provision, the language has to be crystal clear, but you can contractually change the rule.
Absolutely. And to me, this is very simple. Otherwise, if you don't have a provision like this, it's a riskless exercise for your client to at least initially resist paying the indemnification provisions because they know that the worst award they're going to get is what the damages are to start with, and that it's not going up by the fact that they litigated for a while.
Yeah, but Joel, guess what? It's really nice that a court is going to enforce this provision, but in this case, no court is going to get that chance because I'm just going to reject this provision outright. I'm going to do one of two things. One, just cross it out, as I've done here in the markup, or I'm going to replace it with a more balanced, symmetrical provision that says, well, in the event of an indemnification dispute between the buyer and the seller, the court or arbitrator that ultimately decides that dispute will determine the prevailing party, and the non-prevailing party will pay the prevailing party's legal fees. That, I think, is fair. You good with that approach?
And that I might be willing to live with. Not the part that says the arbitrator, because I abhor arbitration provisions in these kinds of agreements.
Oh, wow. How many of you on the buy side put arbitration provisions in your purchase agreements or contracts just out of curiosity to see? Really? That is so alien to my experience representing large, often tech-oriented strategic buyers who almost always put arbitration provisions in there because they don't want to get a public reputation for suing the target companies or their owners. Joel, do you really avoid arbitration on the buy side?
I do, because in the transnational context, you sometimes have to accept it because you can't find a court system that both parties would agree to. But I tell you, it is representing a buyer, particularly if there's a great disproportion of size, that the buyer is very, very large. It's like a large strategic, and they're suing a founder. I really don't want an arbitrator's ability to be sympathetic. I want a jury trial waiver, and I want a judge to have to write an opinion.
And your buyer clients, your big buyer clients, big strategics in any industry sector are willing to let these disputes play out in the public forum?
Very different if you're talking about operating agreements, supply agreements, even JV agreements. We like arbitration, but for M&A, no.
My experience is just very different from all that. The way we typically set it up is court for any pre-closing dispute. So, for example, if there's a situation where the buyer is claiming that a closing condition hasn't been satisfied and is attempting to walk away from the deal, and the target company says no, specific performance and various other judicial remedies that can be important here, and the buyer may want various remedies that are more suited to courts, fine. Have that in court. But when it comes to indemnification in particular, the most important post-closing covenant in many deals, almost universally, are arbitration. I would think that so much of what comes out in those disputes, depending on what the nature of the reps are that are being targeted, would be the kind of stuff that you wouldn't want to see play out in a public forum. So anyway, let's get back to legal fees, and I'd like to go back to the third-party lawsuit scenario, because in addition to your parenthetical in the definition of damages, you've included a clause in the operative indemnification provisions that I actually had to read twice, Joel, because I couldn't believe my eyes the first time. It's labeled a non-meritorious claims indemnity, and let me read it. It just says, seller shall indemnify buyer against any damages incurred by buyer as a result of, at least we don't have directly or indirectly in there, any claim asserted by any third party that, if meritorious, would constitute or give rise to an inaccuracy in any of seller's representations and warranties. So let me get this straight, going back to my example of the third-party infringement lawsuit. If some misguided third party brings a completely spurious suit after the closing, alleging pre-closing patent infringement by the target company, and the third party loses that suit, then I think you'd agree my client's non-infringement representation remains 100% accurate, right? There was never any infringement pre-closing. Do you actually expect my client to indemnify your client for its legal fees incurred in successfully defending the spurious, non-meritorious lawsuit when there has been no breach of a representation? The deal is, and I'm going back to the original indemnification language here, the deal is, in the actual indemnification language up on top, that your client should only get indemnified if there's a breach, an inaccuracy in a rep. And now you're positing a situation where the rep was 100% true and you're asking for tens of millions of dollars of legal fees that you incurred because I allowed you to defend third-party claims even though I'm paying the freight. That's a point you won on earlier.
Yep.
I understand it, but now you want me to pay those legal fees even though there was no breach of a rep.
Yeah,
How do you justify that?
I do, because for two reasons. One, very often, even the claim we prevail on is going to be focused on conduct that occurred during your client's watch. One example from your part of the world is I buy a company that was a development stage company, and then after the closing, a dozen ex-employees show up waving the offer letters they got when they first came to work for your client. And they say, oh, this provision of the offer letter, while it doesn't say that I get stock, kind of implies that I get stock. And, I'm going to ask a court to award me a portion of the deal price based on this ambiguous letter. And say, we win that case. But it's still, the only reason we went through it was because of things that your client did prior to the closing, which formed the basis for the lawsuit. Second thing I should mention, which is kind of interesting given my skepticism about the fullness of coverage of rep and warranty insurance, is a typical R&W policy will cover that stuff without question. I mean, you don't even have to ask for it. The base form, they cover what they call defense costs, and defense costs include the costs of investigating, defending, all stuff relating to a claim which, if successful, would trigger a loss. It's kind of hard to find it because all that content is typically in the definitions. It's not in the insurance clause, but it's in the definitions, but it's there. And in fact, at least what I'm used to is an agreement from the insurer that they will pay those costs as incurred once you're through the retention. You don't even have to wait till resolution. Now, from the insurer's perspective, of course, and from your client's perspective also, that is eating away at whatever cap we agree on. It's not found money.
No, of course. And look, I guess maybe in my attempt to administer the coup de grace here, take a look at your ABA deal point studies. Once again, they confirm that non-meritorious claims indemnities, very rare, less than 10% of the time do you see them.
I will agree that in M&A agreements, you often don't see it, but I think representing a buyer, you should see it more often. That it is something that I think some people don't focus on, and certainly the clients don't focus on until they've gotten into a situation where they've spent tens of millions of dollars defending, say, a patent claim that was purely pre-closing, and they won. And their lawyer says, sorry, we really have no basis for claiming against the seller.
Right. And look, out of character, I completely side with Joel on this one. I think non-meritorious claim indemnities are fair. And I'm actually shocked not to see buyers negotiate for it more often. I know in my representation of large and mega cap strategic buyers, they get this provision almost all the time. And now, of course, by definition, you won't see PE buyers negotiate for this in no indemnity deals because there's no indemnification provision to negotiate. But the insurance analogy that you mentioned, Joel, is somewhat compelling here. So that on the buy side, market practice needs to change on this one. This is something that buyers, I think, should almost universally be demanding in their deals, just to cover the situation that I mentioned. It creates perverse incentives, too, doesn't it? The notion that if you do a really good job of defending the non-infringement claim or the capitalization claim, that your client loses.
That's right.
And that you should do a crappy job so that the seller will be responsible for the results of that crappy job and the legal fees. So,
and also, if you don't have a non-meritorious indemnity, it complicates even more the question of getting consent to settlement.
yeah.
Because if non-meritorious claims are covered, then there's really nothing that the seller should be arguing about as to whether this is a settlable claim.
Yeah, I will tell you that one thing that many buyers do, even if they don't press on the non-meritorious claims indemnity, in the case of capitalization, there will be a separate line item indemnity for capitalization or any claims made that relate to capitalization. They won't say whether meritorious or not, but that's the effect of the language. And most buyers are covered in the capitalization context.
Yeah, but there are others, and patents are a good one because those cases are so damn hard to defend and so expensive. Another one would be antitrust. If there was conduct pre-closing that is ultimately alleged to have violated the antitrust laws and the standards are hazy, should the buyer really have to live with covering the cost of defense?
Okay, last topic of the day, Joel. Your overreaching reps and warranties. There's a lot more for me to complain about here, including your very broad no undisclosed liabilities rep that extends far beyond GAAP liabilities to contingent and unaccrued liabilities. We won't get into that debate here today. But the rep I'm really most troubled by is your so-called 10b5 rep. And let's look at it. It's pretty convoluted, embodying as it does the confusing and well-worn double negative verbiage of SEC Rule 10b5. It says seller represents and warrants to buyer that neither this agreement nor the disclosure schedule contains any rep or other statement that omits to state a material fact necessary to make the representations or other statements therein in light of the circumstances in which they were made not misleading. There's that double negative part. But if I read it correctly, it's a catch-all rep that goes beyond the other 30 dense pages of representations and warranties that you've already included in this agreement. What else beyond those 30 pages of dense representations and warranties could you possibly need coverage for, and why? And why are you looking to this provision to provide it?
Rick, first of all, it doesn't go totally beyond the reps. Any claim under this has got to find a nexus in a specific line item representation because it has to be, the omission has to be such as to render the representation and warranty misleading. I'll take out the...
Joel, you wouldn't have put this in unless you thought you were going to get more coverage somehow than if we didn't have it in there and had all those...
But I'll give you a couple of examples because I will tell you to start with, I've never actually had to litigate one of these things, but a number of years ago I was doing a diligence project for, in connection with a sell-side assignment. And it was for a company that operated all over the world. And we were sending questionnaires out to every division asking for schedules of contracts and da-da-da-da-da. And one of the things we asked them for was a schedule of real estate that they owned, leased, I forget, we may have used a couple of other words, but that they worked with them. And one of the countries sent back this thing that said none, and which was kind of interesting because they had a factory there. And the general counsel of the company and I called the local manager, who's basically said, I don't know, I asked my lawyer to fill this thing out, but he knows our business. And we talked to the lawyer, and he said, no, we don't own that, and we don't lease it, and we don't rent it. We license it, and that's different in this country. And you didn't ask about licenses. Well, if I forget to ask about licenses in the basic real estate rep, I don't want you saying because it has a slightly different connotation, it's outside. That's where I can use this. It's a gotcha representation. It's also the case where if you...
Well, so you want coverage to cover the ineptitude of your own local counsel for not having realized
right.
that the reps should have been
That's
worded
absolutely
more broadly.
right. And a second example, I mean, think of yourself, let's look at the money laundering world. If you give me a representation that says you've scheduled every agreement of a certain type that involves $10,000 or more, and you know when you agreed to that number that because your client deals in cash all the time and doesn't like filling out these pesky bank reports, it structures every contract to be broken down into contracts of $9,999, even if you sign 20 identical clients, which is probably a violation of the banking rules, but it's also, I would say, rendering this representation misleading. Hard to prove. But, this is not a standard that's new. I mean, this is a standard which every sale of securities in the United States that uses the jurisdictional means of the 34 Act are subject to under Rule 10b-5 itself.
This is such an amorphous way of trying to cover this nebulous risk. If there's something you missed, put an explicit rep in that I can actually deal with and respond to on a disclosure schedule, not some confusing amorphous catch-all rep.
But how can it be that confusing if we now have at this point 80 years of precedent construing it into the federal securities laws? This is not, these words are deliberately copied from Section 11 and Rule 10b-5.
Yeah, so let me just step out of character here for the benefit of the audience, because you get this argument a lot from buyers who are trying to justify a 10b-5 rep. They're saying, hey, look, you're covered by 10b-5 anyway, right? What was the case? Landreth Timber going all the way back that says that a sale of a business, if it's structured as a sale of stock, as our deal is, it doesn't matter that it's a sale of an entire business. It's also a sale of stock, and it's covered by 10b-5. So you're covered, right? So why do you object to just enshrining these protections that apply to you anyway in a rep that just memorializes what you're subject to anyway? And the answer to that question, and it's the answer that all of you attempting to resist this should be giving, is, well, because the effect of that rep is very, very different from the effect of the SEC rule. For your client, Joel, to recover from my client for a violation of SEC Rule 10b-5, your client has to overcome a lot of hurdles, several species of causation, reliance, at least in cases not involving an omission, and most importantly, the scienter hurdle. You have to prove that my client, the seller, acted with scienter, with evil intent, among other things. We can argue whether scienter includes
doesn't mean evil
recklessness.
It can also just include knowing facts to the contrary.
Fine. But to recover for a breach of the contractual rep, the buyer doesn't have to prove any of that. And even if my client didn't know the rep was inaccurate, even if my client thought the rep was accurate, so had no knowledge whatsoever, my client can still be liable. The rep breach is akin to a strict liability offense. So I'm not buying your disingenuous argument that this is no different from Rule 10b-5. I concede that you can't read SEC 10b-5 too broadly. It doesn't say, I've told you everything that's material. That's not what
I thought of that, but we didn't
10b-5.
put it in the first draft.
Yeah, I'm sure. And by the way, I've actually seen buyers get away with a rep like that. If you have a buyer that puts in his or her first draft a rep that says, you've disclosed everything material to me, it's time for you to pack up and go home and say, I just can't deal with this kind of negotiation, because that would be outrageous.
Yeah.
But the 10b5 rep is somewhere in between. I would also point out, Joel, that this rep is not market standard. The latest ABA private deal point study shows you see this rep in less than 10% of the deal. The 10b5 reps were very common 15 years ago, but according to the latest deal point studies from the ABA, they're out of fashion. You need to
Although
get in step with
it's
the times,
interesting,
Joel. Yeah.
the markets are diverging, because I dare to say it's a lot more common in the giant cap strategic acquisition agreement than the ABA studies indicate. On the other hand, it's almost non-existent in private equity, sponsor to sponsor.
Well, yeah, let's talk about that. Because, well, first of all, just to close it off on the strategic side, you're going to ask for this and you're going to press for it. And I agree, out of character. 10b5 reps are useful, and they can be very valuable, and they do provide material amount of extra coverage. And the 10% statistic you see from the deal point study is really a different market. But let's distinguish again between the strategic acquisition marketplace and the PE marketplace. And I think that's where we're going to close, because we have about a minute and a half left. If your client, the buyer, is a PE sponsor and my client is a PE seller, you're not even going to ask for this rep, right?
I'm not, and one of the reasons is that the dynamic is a little bit different there, because most sponsor-to-sponsor deals start as auctions, even if they don't finish as auctions. And so you're working off a seller's form agreement that was put in the data room, and you're telling all the potential buyers, mark it up, but mark it up as little as possible, because every change you make is going to be held against you. And so it's not that you can just stick it in the form and hope that the counsel on the other side decides not to make a fuss about it. You've got to add it so it shows up as a nice red line when the draft comes back. And I think a lot of people won't do that. I won't normally.
Right. And the fact of the matter is that from a strategic buyer standpoint, considering whether to use rep and warranty insurance, this is a disadvantage of rep and warranty insurance. They won't cover, in my experience, 10b5 reps, unless anyone in the audience tells me that that's moving in the direction of interim breach coverage. You can sometimes get it. I don't think it is. I don't think you can ever get it. Well, thanks for your attention, everyone. We obviously haven't been able to get to anywhere near all or close to even all of the contentious points in the negotiation of a strategic or a private equity acquisition, but just a handful to give you a sense for some of the things that buyer's counsel or seller's counsel may not be doing as good a job as they should be doing on. And if you have any questions, feel free to raise them. I guess there's a reception right after this, so we'll look forward to seeing you there, and thanks for your attention and your patience.